We're here today to start our Friday afternoon sentencings. Again, there's a lot of sentencing set. There's a lot of defendants with multi-files set. So it will take some time to organize this, and we will proceed accordingly. I do a separate file for each defendant. I don't start the recording in the YouTube video until we're all prepared and that we've covered all matters that may be of a private nature ahead of time, so that that's not put on YouTube. And we proceed when we're ready. And so that's the procedure for these cases. If you're wondering why I do it different than other judges, that's why. My goal is to never be a viral sensation, and to avoid that by not having anything come on that isn't ready. So with that, as an explanation, the reason there's a delay at the beginning of every hearing is because I have to spend about 30 seconds to make that the chat is off on YouTube for each case. So that's in terms of some questions that were raised regarding my channel or my station. That's why I do those things, and that's why it is that way. We're going to begin with Mr. Williamson's case. This is People of the State of Michigan versus Brandon Williamson. He was set for last week. I asked that it be adjourned so I have a better opportunity to review the matter. In the hearing room today is Mr. Williamson, and he has two attorneys, Mr. Bush and Ms. Halleck, on these four cases. We also have the prosecutor, Mr. Gabry, and in the room also is Marissa Countryman, the victim witness coordinator for the prosecutor's office, and Lisa Martin, the supervisor for our local Department of Corrections Probation Parole Office. With that, in file 2023305, he is represented by Mr. Bush. And in file 2023477, he is represented by Mr. Bush. And in 2023478, he is represented by Ms. Halleck. And in 2023526, he is represented by Mr. Bush. Now, Mr. Bush and Ms. Halleck, does Mr. Williamson have any objection to conducting this sentencing with him at the jail on video?
He does not, Your Honor.
No, Your Honor.
All right. So we adjourned it from last week, so some corrections need to be made to the pre-sentence report. First is that the date's now May 28th, and there's 7 additional days to each file for jail credit. Now, beyond that, Mr. Bush, you have the majority of the cases. Do you have any other additions, corrections, or deletions?
Yes, we met a couple of weeks ago. I discussed this case with Mr. Williamson. He only pointed out one correction to me on page 2 of the report. Well, that would be page 2 of the evaluation plan, I guess.
Okay.
There is a reference that calls were placed to Ms. Bowdish on 5/14 of 21 and 5/18/21. No one answered, so messages were left. He would only like to have included that his mother did return the phone call to the Department of Corrections and left a voicemail.
Okay, but at the time of the report, the call had been left and there were messages left, but so as accurate as the time the report was written, right?
Well, you know, I'm not sure when his mother actually responded to the voicemails, other than I can't answer that.
All right. Ms. Martin, do you know? I think the concern is the defendant has is that it would suggest that his mother wouldn't bother calling back, but we'd like it noted that she did.
Okay, I will add that.
Okay.
Do you know when, Mr. Williamson?
She was at work.
Know what day?
I don't know exactly what day she received the phone call, but I called her and she said that somebody from the Department of Corrections had tried to get a hold of her and left her a message. And she said she tried to return the phone call, but there was no answer.
All right, I'll check with Agent Griffin.
Okay, so mother did try and call back. Thank you. And we'll note that at the end of that paragraph. What else, Mr. Bush? Anything else?
It's my understanding with that correction, the body of the report is accurate, Your Honor.
Okay, Ms. Halleck?
That was the only correction that we noted as well, Your Honor.
Mr. Gabriel.
I have nothing, Your Honor.
All right, let's do scoring for each case separately. 2023305 on the charge of assault with a dangerous weapon. The agent recommends the prior record variable be scored at 45 points, level D.
No objection from me.
I think it actually should be scored at 40 points, Your Honor. On the prior record variable, I believe should be 15 points. Does not
Which
change. Does not
Which one?
change. Prior record variable 5. I think it boils down to the date of the misdemeanor convictions.
I have 5 prior record variables for 5 misdemeanors. And 5 would be 15 points for this file. Mr. Gabriel?
Fine with me, Your Honor.
Okay. 15 points under PRV 5. That would make it 40. Still be a level D.
That's
Defense
correct.
variables. 25 points.
I have no objection.
No, none with me, Your Honor.
All right, so the guideline range would call for an advisory guideline range would call for a sentence of anywhere from 5 to 23 months on the minimum. Two zero two three four seven seven. And here, Mr. Bush, on the charge of carrying a concealed weapon, the agent recommends 50 prior record variable points.
Your Honor, I would ask the court to take a look at PRV 5. Again, I think it should be scored 15 points.
Could I ask defense counsel to point out which ones he thinks do not apply?
The 2 later misdemeanors that I believe were that came after the date of the alleged offense.
21 and 22? Seven.
It would be 19 of 22 and 21 of 22.
And 22 of 22. So, Mr. Gabriel, I count 5 prior misdemeanors before this offense.
I agree, Your Honor.
So 15 points, no objection to the other scoring.
No objection.
So it's 45 points. Does that change the guideline range?
Yes.
I believe it does, Joe.
Okay, it's now a level D. This is a E-class felony. So 45 points would be a level D. Any objection? The offense variable is 20 points.
No objection, Judge.
None, Your Honor.
That would be a D2, so it would be 7 to 23 rather than 10 to 23 as scored. (20-23478). That's a sentencing offense that occurred on August 17th, 2020. And so therefore, that one's not scored. That one's not scored. Again, it looks like 5 before this one. So 15 points for PRV 5. Ms. Hallett?
Yes, Your Honor.
Fine, Your Honor.
Okay, 25. And in this one, it's a E class again. 25 points would make it still a level D. Offense variable 5 points.
I have no objection.
No objection.
5 to 23 months then. And 20-23526 with a date of August 7th, 2020. Again, 5, 15 points, 35. Okay, so 35 points.
Yes, Your Honor.
That's fine, Judge.
And this is a D grid. So 35 points equals D still, and 0 offense variables.
No objection.
So 0 to 17.
Correct.
Okay, good. We've gotten through the scoring part of each case. Now, allocution. Here I'll hear from both Mr. Bush and Ms. Halleck, then I'll hear from Mr. Williamson, then I'll hear from the prosecutor. Go ahead, Mr. Bush.
Thank you, Your Honor. Mr. Williamson comes before the court at a very young age. He's only 18. There's no doubt that there's significant substance abuse issues. The age he was introduced to methamphetamine is kind of astounding as you look at this case. He's had an awful life. He was a criminal sexual conduct victim. His father's passed away from meth complications. Just about everything that we could think of has gone wrong with him. But he tells me that he wants to do rehab. He wants to get involved in services. He's got a lot happening. His grandmother is apparently terminally ill. Mr. Williamson had hoped to be able to do services locally, but obviously with his circumstances, apparently the what we commonly call the boot camp program is probably going to be his best options. He needs a lot of things: job skills, a GED, stability, probably some anger management, and most of all, he needs structure in his life. All of those things that can be served with probation. I would ask the court to give him the opportunity to do any type of a rehab program in advance of any commitment to the Department of Corrections. Thank you.
Thank you. Ms. Halleck?
I think that John, that Attorney Bush covered what I had also discussed with Mr. Williamson, which was the substance abuse being a big issue at a young age too, and needing the structure. What he said to me was, you know, whatever happens, happens, and I'm gonna do it and get this and move on with my life and have a different life. So he knows those choices are in his hands. He was very mature in his response for so young, so accepting of the consequences. He would prefer to stay locally, obviously, with his grandmother sick, and do some form of probation and eat together. So, but he does need substance treatment for sure. Underlying issue with most of what we see here today, pretty much everything. So we would just ask that that into consideration.
Thank you. Mr. Williamson, what would you like me to know?
Your Honor, I would just like you to know that I accept responsibility for all of my actions. I ask that I can receive any help that the courts will give me as far as rehab or substance abuse treatment. And I apologize to all of my victims that I've harmed or made any turmoil in their lives.
Thank you. Mr. Gabriel?
Thank you, Your Honor. I guess I get to be the odd man out here. And, court's aware that I basically recognize that it's a court's responsibility to determine a fair and just sentence using all of the factors, weighing all of the factors that go into that. Mr. Williamson is, I think, pretty much the first of a series of individuals that I'm going to be and have gotten before the court, and the court will be dealing with, that are not here because they committed a crime and then went through the process and either resolved it or whatever. He has been given a substantial break, given the charges that were originally filed. Why? Well, we're coming out of COVID. We're coming out of period of limited resources and cases that need to be tried. But what really concerns me, Your Honor, is that the arguments that we hear from defense counsel would be moving to me anyway. If we're dealing with an individual that committed a crime or maybe had a relapse while on probation. But we have individuals that go on tears, that commit a crime and get caught and commit another crime and get caught and get let out and commit another crime. And we're putting a huge burden on the community, the public, to have these individuals continue to be there, and Mr. Williamson to be there. It's my opinion, and for what it's worth, that an appropriate sentence is the high end of the guidelines, is the 23 months to whatever the maximum, I guess it would be 10 years in this situation, in the Department of Corrections would be done. The court's well aware that he's going to get credit for the time that he finally did serve in jail when he got those bonds, situation where he wasn't able to be out there. In addition to that, the 23 months is under the ceiling for special alternative incarceration program that's run by the Department of Corrections, affectionately known by many as the boot camp. And he doesn't even have to do the whole 23 months, but he goes to prison. He gets his initial taste of quarantine. If he medically and mentally clears, the court will be given an opportunity to allow him to go into boot camp early and then go on a special period of parole supervision. The idea and recommendation that this boot camp be through probation, if I understand everything correctly, given changes that we have to deal with as of April 1st, is that fine, as a condition of probation, he goes through boot camp if he wants to accept it. I assume he would accept probation. But if he violates that probation when he gets out, even if it's because he failed boot camp, he goes back in front of the court, and we know what the legislature has directed the court to do on probation. So I think we can address the concerns that Mr. Bush and Ms. Halleck have for Mr. Williamson. We can give him the program. Yes, there'll be more of a period where he will be awaiting his opportunity to back up what he says. But if what he's saying is sincere, he'd be able to be entered into the program. And if he successfully completes it, he can work off his parole and go on to being a citizen that we can be proud to have as a member of our community. That's the position that I asked the court to consider as it makes its decision.
All right. In looking at these cases, the first case, 20-23305, May 3rd, 2020, at the peak or at the beginning of the COVID outbreak, where everything is in lockdown, everyone's supposed to be at home. Police are dispatched to Sturgis. People were screaming in the streets about someone having taken some property, a bicycle that had been stolen at knife point. They advised the suspect was a white male wearing blue jeans, a white hooded sweatshirt, and Nike Air Jordans, seen riding the bike on East Congress Street. They spoke with the witnesses, they described, and they then found the defendant along with items and the knife that was used. And described it by everyone, and then the rest. Then on July 13th, after being charged with that and released, and when officers informed him of the charges, he said he wished to give police information regarding other stolen property. And they said that could be done later. Advised he believed that he had been assaulted, and goes on. So again, he had more information to provide, and they said they'd talk about it later. So he was charged with attempted armed robbery and possession of drug paraphernalia, dropped down to this charge of felonious assault. 20-23477 occurs on July 13th, just 2 months later, where Mr. Williamson was arguing in the street with another, ran on foot. Gun had been taken from Mr. Williamson and was secured. Upon arrival to the area, the officers located a male and female, flagging him down. They said that they were Mr. Williamson's brother and sister, and that another person had just wrestled with Mr. Williamson and taken a gun from him. They pointed at the gun. The magazine was out of the gun. The officers then secured the gun, and the witnesses described the defendant. Sister said that she noticed a gun in Brandon's waistband, asked what he was going to do with the gun. Defendant said it was a BB gun. She said, no, it's not. And then he said that he had been at a house where somebody pulled it out on him and he took it away from them. And then he ran to his house. So there's that issue with the gun where he took off. And the rest. And then the victim said, no, that never happened, that he had the gun. 2023478 is then just a month later regarding a stolen moped. Made contact with the person, said that it had been in his, had been sometime during the previous night, did not know when. Described his moped as a Harley Sportster. Made contact with the defendant's grandmother and spoke to the defendant at the jail. He provided a full confession of being the driver of a van that was used to pull the stolen motorcycles, moped in Indiana, and the bike was seized in LaGrange. He had stolen the moped and other motorcycles with a suspect named David King, who was in LaGrange County. And investigators were able to retrieve some video surveillance of the motorcycle being stolen from the Meyer storage. And then 2023526, August 7th. Passenger was Brandon Williamson. Williamson had a warrant, requested Williamson exit the vehicle, became upset, was whining. He subsequently placed into handcuffs and then admitted he had methamphetamine on. Now, defense counsel argued for probation with term supervision. These are all straddle cells. The ones that are straddle cells, there's ones that are intermediate, which means a local sentence. So here's the thing, the prosecutor is arguing that this should be a prison sentence with the ability to do boot camp or SAI. The SAI program is a 120-day program where he can be released after serving 120 days once he enters the program, and then he's based on intensive parole for a short period of time, as compared to the probation. Now, my experience is that on parole, he won't have any consequences. The prosecutor argues that if he's put on probation, I'm limited as to what I can do on any probation violations. And my experience is that on parole, there are no consequences, except a stern talking to by your parole officer as to what will happen if you continue to violate, unless you go so far as to break a new law, whereas on probation, I could see him for any violation. And these are all new statutes that took effect April 1st, and it's difficult to know which is which. But as Mr. Gabry argued, this is a whole series of activities involving assaults with weapons, involving the use of a gun, involving dangerous behavior in the public and continued pattern of criminal behavior that is a danger to society. And whether it's best or not, these were dropped down from the more serious charges. I recognize that this does resolve these cases and provides finality for both Mr. Williamson and the victims and the rest. All right, even though it will probably end up in a lesser sentence, I'm going to follow the recommendation of the prosecutor and turn this over to the Department of Corrections. This does deserve a prison commitment. The use of weapons, the assaults on people, justifies that. And hopefully Mr. Williamson takes this advantage to learn from the programs and moves ahead accordingly. So in file 2023305, you're sentenced to a period of 18 months to 4 years in the Michigan Department of Corrections. Credit for 68 days served. There is a $68 state cost and $130 crime victims assessment. I won't order any additional court costs, fines, or attorney's fees. In this case, Mr. Williamson, your sentence is pursuant to your plea and within the guidelines. Therefore, you have the opportunity to ask the Court of Appeals for leave to review your case and for the appointment of an attorney at county expense in order to do so. In file 2023447 on the charge of carrying a concealed weapon. What?
You said the wrong. You read the file number wrong.
What is it?
23477.
What did I say?
244.
23477. 17 months to 5 years in the Michigan Department of Corrections. Credit for 44 days served. Run concurrent with the other files. And here again, $68 straight cost, $130 crime victims assessment. In the next file, 2023478, charge of unlawfully driving away an automobile. Sentence of the court is 255 days, credit 255 days served, $68 state cost, $130 crime victims assessment.
Your Honor, there is restitution in that case.
Yeah, how much was that?
Five.
$762.50.
Correct.
So $233 to Wendy Binkley and $529.50 to Progressive Insurance. Did I say 255? Because it should be 262. 262 credit 262. Probably had the other one.
The other,
How much did I give him on the first one? 68
68
days
days,
credit?
Judge.
144.
Should have been 51 on the second one.
51.
Yep. And on the last one, 2023526, 226 days credit, 226 days, $68 state cost, $130 crime victims assessment, license sanctions, good through October 1st on those. Now, Mr. Williamson, on all these cases, you'll be given 3 forms advising of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you need to fill those out, return to the court within 42 days. All right, that